In this episode of the Entrepreneur Project Radio, we have a discussion with Ed Ramirez, a millionaire inventor and co-owner of the Entrepreneur Project, to discuss exactly what patent pending means, the importance of patent types, and we even dive into IPR and everything you need to know to protect yourself. Enjoy the episode.
Ed, my process with this is going to be to have this interview with you today. And my goal is to more understand your unique perspective on patents based on your experience.
In your experience, when inventors are going through this process, what are the most challenging parts of the patent portion? You know, what's their mindset when they're going into this phase, in your opinion? What do you think their state of mind is? What are they worried about? What questions might they have?
Okay, with every inventor and every patent, there are two basic frames of mind. One is excitement, and the other one is fear. Okay, the excitement portion of this is getting a patent is a very exciting thing, right? I mean, to become a patent holder, to own a patent, to have your name on a patent, it could give you a lot of benefits in the career world, in the business world. And so there's a lot of excitement behind it. Also, there's an idea that once you get a patent, you're kind of guaranteed to be a millionaire. That's a conception that is out there. Now, again, it's not accurate, but that is what people feel. That's part of the excitement. So I'm going to get a patent. I'm going to have my name on a patent. I'm going to be a patent holder. All these exciting feelings are part of that excitement portion of the mind frame or state of mind. Mm-hmm. Okay, along with I'm a possible millionaire. Mm-hmm. The fear component of it comes with all the uncertainty, which is a patent is usually going to take possibly over 2 years to secure. I don't know if the patent office is going to grant me the patent. I don't know if somebody's going to rip me off once I have the patent. I don't know what my responsibilities are that come with a patent. And I have no idea where the money trail is going to end with the patent. Those are the things that cause fear. Because most new inventors don't have an unlimited corporate budget. They have limited funds, and they're going to be playing a lot of times with their savings.
So it sounds like they're holding these two almost contradictory feelings at the same time, in a way. You know, excitement and also, like you said, fear, and they're having to balance both as they're moving through this process.
Exactly.
Okay.
And that's where the inventor either subsides to the excitement and goes with the feel of everything they need to overcome and goes with the patent, or literally says, I'm not going to do this. Yeah, it's a great idea, but I just can't deal with the risk aspect and the fear part of it.
So it can be kind of a make or break moment. It can be like that litmus test, that gut check, that you're ready to make the next investment with your time and your energy and your money.
Correct.
What tips and tricks would you suggest to inventors beginning their patent search? What should they know about the process? What's something you wish you had known?
Right. So the patent search is either going to strengthen that excitement that you're feeling, or it's going to strengthen the fear that you're feeling and the uncertainty. Because the patent search is going to open your eyes to a lot of information. Number one, there's already 5 or 6 very close products to match your product, or maybe more. And so that's an eye opener. Wow, I'm not the first to think of this. They did it very differently, but I'm definitely not the first. Number 2, none of these products that have a patent are currently on the market. So that is a good thing, because nobody has executed on their patent, which opens up the playing field for you. So therefore you want to pursue your patent. On the fear side, it's like, why hasn't anybody been able to launch their product, their patent? right? So a patent search it's an eye-opening experience because, again, you learn all those things.
Mm-hmm.
Or you learn that nobody has thought of this. There is nothing remotely close to your idea or your invention anywhere in the patent office.
Mm-hmm.
So that means your idea is very, very novel. It's completely new and never been thought of before.
That makes a lot of sense. What are some of those patent pitfalls that people should be aware of so that they don't fall into them?
Okay, so here's a patent pitfall. As I mentioned earlier, people think, and again, most inventors, most just people that have an idea, think that simply by getting a patent, you're going to become a millionaire. There's going to be people knocking down your door saying, hey, we want to pay you for your patent. We want to pay you for your use. We want to pay you to own it. And money is just going to start flowing in. And that is a major pitfall because that never really happens. It's a lot of work to promote your product. It's a lot of work to get people to even consider it. And it's not easy at all to get people to license it. So another pitfall of a patent is the perceived protection of a patent. Yes, you are patented. But that does not prohibit people from trying to steal your patent and infringe on your patent. And so it takes a lot of money to defend your patent. Even though you have a patent, you still have to pay a lawyer or lawyers or attorneys to defend your patent in case somebody infringes on your patent.
Mm-hmm.
And so one of the pitfalls is, oh, I have a patent. I'm completely protected. I'm safe. Well, no, as it was explained to me many, many years ago, a patent is a $30,000 gun that requires a $1 million bullet. You can you have your gun to defend yourself, but if you're going to defend yourself with a bullet, you're going to have to pay close to $1 million.
That is a great analogy.
And it's very, very true.
So it sounds like getting a patent may, if you're not careful, maybe give people a false sense of security in
Correct.
a way. And that it's
absolutely.
It's not the end, it's the beginning.
That is correct. And that is a pitfall, right? Because people don't understand that it is a false sense of security. Mm-hmm. There's a lot of steps, a lot of money you have to invest to actually protect that asset, that patent.
When in getting to the point of, getting that patent, when we're talking about the claims and the drawings and the filing and the grant, it sounds like this is, like you were saying when we first started talking, this is an involved process. This is something that you need to commit to. It's not a fill out a couple of pieces of paper, send them off on the internet and lickety split, you're done. This is something that requires real commitment and involvement on your part.
Yes.
I have a patent. Am I protected? Is that a question that you get a lot from, people who are maybe seeking out your advice or your expertise on this topic?
Yes, because when they're seeking that advice from me, it basically says, well, in their statement is, I'm patented. I have nothing to worry about. Mm-hmm. That's the first thing that comes out of their mouth is when they say, oh yeah, I have a patent. I have nothing to worry about. If the subject of manufacturing in China comes up and the possibility of intellectual property theft comes up, people's response is, oh, I have a patent. I'm protected. Mm. And again, I have a patent. Am I protected? The answer is yes, you're protected, and the patent does offer you certain protections. However, there are a lot of things that need to happen in order to protect that patent, like we discussed earlier.
Right.
Once somebody infringes on your patent, it's not as easy as calling them up on the phone and saying, hey, listen, you infringed on my patent, you owe me $1 million. Mm-hmm. It's a very elaborate process of writing a cease and desist letter, stop doing what you're doing. If you don't stop within 30 days, then we're going to take legal action against you.
It kind of reminds me of how, people think that they can sue for anything. You know what I mean? But almost like the reverse of it. Like, yes, you may have a patent, but if you need to take legal action, if you need to enforce that patent, it's not like there's a magic wand that's going to make everyone obey by the rules. It's going to be a process, and you should be prepared for that.
Exactly. To your analogy of, you could sue anybody. A lot of people, the majority, run around thinking, if for some reason I chew on a bad piece of gum, Wrigley's owes me $20 million.
Right.
And it's not that easy. There's a process that needs to happen, which will cost you $10 million to possibly get $20 million out of Wrigley. And I'm just using that as an example.
Right. I have a patent. Can I go to market now? And I have a feeling that the answer to that is going to be more complicated than a simple yes or no. What is the answer to that question?
Yes, I have a patent. And can I go to market now? The answer is yes. Without a doubt, the answer is yes, right? Because all of the previous videos and all the previous text is be careful, don't say anything, do not disclose, do not talk to anybody. Mm-hmm. And so it is a straightforward yes, but always just be careful and monitor the market.
Mm-hmm.
All right.
Tell me a little bit more about what you just said about how confidentiality and kind of playing your cards close to your chest is important through this patent phase.
Okay, so if you go to the section called patent pending, what does that mean for me? Mm-hmm. Is you have no idea how many people I meet at trade shows, they're inventors, myself included. I will include myself in this. Where you are patent pending, that means that you filed for your patent, you've paid the initial money, you've paid your attorney, and now you're waiting for the patent office to review your case and possibly issue you a patent, right? Mm-hmm. That amount of time can range anywhere from 2 years to 10 years.
Wow.
Of you being patent pending. However, attorneys tell you, you are now patent pending. You're protected. Go to market. Go do what you need to do. That is a very misleading statement, because what they don't tell you and what they fail to tell you is, although you're patent pending, and yes, you are protected when your patent issues. That could be in 2 years, that could be in 3 years. So that means that if you're patent pending and you go to market and somebody steals your idea, they could steal it for 2 years or for 10 years. And you can't do a thing about it.
That is definitely a period of uncertainty.
It is a huge period of uncertainty, and all attorneys say that to their clients. Hey, you're patent pending. Don't worry about anything. Go for it. You are now protected. So not true. So in our case, what ended up happening with us is we were told, okay, you are patent pending now. Go do what you need to do. So I approached one of my competitors, and I said, hey, I would like to license this product to you guys. They said, nope, we don't want it. Go pound salt. The next year, they released their product using my technology. I immediately got upset and said, hey, we are patent pending. I'm going to go after you. And I called my attorneys, and they said, well, you can't do anything until your patent issues. And I'm like, what? But you told me I could go to market. He goes, you can. But once the patent issues, then we will sue them.
Not until it issues.
My patent took 8 years to issue, Annie.
Wow.
So for 8 years, this company dominated the marketplace. By the time my patent issued, they basically came to me and said, okay, we're sorry. We'll give you $100,000 and you walk away.
Okay, so what can you do then if it's patent pending? I mean, do you just sit quietly until it's officially passed, or are there, more discreet things you can do to, put yourself in a good position to launch? I mean, what do you think?
Yes. So our advice to our clients when they are patent pending is, like you said, stay quiet. Do not go try and sell your invention. Do not go try and market your invention. Stay quiet as long as you can until the patent issues, because if this is a valid invention, if it's a good invention, you will get ripped off with the knowledge that they will pay you something when your patent issues. And it could be 50 grand or it could be 20 million, depending on how successful the invention is. But you're supposed to stay quiet. And that's the attorney. The attorneys don't give you that advice. The attorneys say you go to market, go do what you need to do, you're protected. You are not. So what you should do is continue to do all of the other, what we call housekeeping items within the invention process, which is find out how much this product is going to cost you to make. Find out if it's marketable. Find out if you want to do this or if you want to just sell the patent. Find out all those things that'll take you a couple of years to find out while you're waiting for the patent to issue.
So it's not like you have to sit there for 2 years kind of twiddling your thumbs. There's a lot of, it sounds like you can really do yourself a favor by really exploring the idea and using that time to your advantage.
Correct. With the knowledge that you're not going to be able to capitalize, you're not going to be able to go out there and make a bunch of money when you're patent pending.
That must be hard for inventors who are probably chomping at the bit after this process to get their design out there,
Yes.
invention out there and make some money off of it. They've invested some time and energy.
And now, if for some reason this invention is super novel, super hot, it's going to change everything, then it is worth taking the risk and go patent pending, make a bunch of money. Now you got money to defend yourself when people do rip you off, and you try and kind of beat them to the punch.
Okay, so it's kind of a weighing the risks and the reward of the
Correct.
scenario.
Yes.
Okay, so it's almost like an internal formula, like how much risk is there, how much reward, how timely and relevant is this product right now, what's my potential earning opportunity, and kind of putting that all into a calculation in your head to decide, okay, should I go patent pending or not?
Exactly.
But really, it sounds like the main point is that the big mistake is to just go to market when your lawyer says you're patent pending.
Exactly. And approach other companies and try to sell your idea, your invention. And you're a small guy, you don't have all those resources. And people know that they can just rip you off because you're not going to have money to defend yourself.
So people can really take advantage of you.
It puts you in a very vulnerable position versus wait a year or two, get your patent, and then go approach these people. You do take the risk that somebody else is going to invent it as well, and now your invention is useless. But the chances of that happening are very rare compared to the chances of somebody ripping you off because they know you're 100% vulnerable. Just a couple of types of patents: a utility patent and a design patent. Okay, and so. And there's also what they call a provisional patent and all kinds of weird little terms that some attorneys use. But the reality is there's two patents, a utility patent and a design patent. A utility patent is very expensive. It's very detailed, and it is what actually protects your invention, what the invention does. A design patent is how the invention looks. A design patent is very easy to beat in court. So design patents tend to be worthless.
Okay.
But they do serve an intimidation tactic, which your average Joe that is going to try and rip you off on your design if they see that it is patented, they'll be a little more deterred than you have no design patent at all.
Mm-hmm.
So how a product looks is a design patent, but anything can change it, right? So if you have a design patent that is in the shape of a circle, right? But you design it more in the shape of an egg versus a perfect circle, you've already designed around it.
Right.
Because you changed it. And that's all you need is one simple change of the design element, and therefore your patent is no longer the same. It's a different patent. And so they tend to be very inexpensive too. A design patent is probably, I think, $1,200 or something by the time it's said and done.
Okay.
Whereas a utility patent will basically start at $35,000.
Wow.
A design patent can be issued by the patent office in about 6 months. A utility patent, as we have discussed, takes somewhere between 2 years to 10 years
Mm-hmm.
to be able to get a utility patent. A utility patent is worth a lot more money than a design patent. Design patents are, again, they're not worth anything.
Mm-hmm. Should you have an attorney before you start working through this patent process, or is it something you can start on your own?
It's something you can start on your own, and that's what we're going to be coaching people to do in our portal in previous videos, which is to perform a patent search on your own.
Okay.
Attorneys can do it for you, but they'll charge you X amount of money. And just to get started to do a patent search, you can do that for free.
Well, and it sounds like it's a good exercise for you to do on your own. It sounds like you learn a lot by doing it rather than hiring someone to do it.
Correct. One last thing that I want to cover with you, which is very interesting, and it's one of the hottest topics on this block right here, is the IPR. Okay? And I have very intimate knowledge of that because the IPR completely devastated me. IPR stands for Inter Partes Review. I think it's like a French term.
Yeah, I was just looking that up.
And what the Inter Partes Review does is, and this is new legislation. When I say new, I'm talking the last 5 years. Legislation was passed that allows anyone to challenge a patent. That didn't exist before. Before, if you had a patent on a skateboard, that's it. Your patent was your patent, and it doesn't matter what anybody said. You had that patent and you owned it for 20 years, period. The IPR process was instituted in legislation in which it gives any entity the opportunity to challenge that patent. So here you are, Annie, you're running around with your patent on skateboards, and Mattel Toys decides that they're going to challenge you. And so they file an IPR. Once they file the IPR, it puts the patent office on notice that your patent is being challenged. So now you have to prepare a defense brief, which starts at $40,000 to argue to the patent office that Mattel Toys is really full of it and they have no chance to, no reasonable being to go after your patent and challenge it. Then Mattel Toys files their counter to your defense. Oh, sorry. They have already filed their IPR on you. You defend yourself with a $40,000 defense. The patent office takes all that information and creates a ruling. The ruling is, yes, Mattel has a leg to stand on because they demonstrated to the patent office that this guy named Hans in Germany had a skateboard patent in 1952
Oh my goodness.
that you, Annie, did not pick up in your patent search.
Wow.
And either did the patent office. The patent office missed it.
Mm-hmm.
So now the patent office gives the green light for there to be a hearing. That hearing is going to be about $150,000 to pursue.
Wow.
At the end of that hearing, there's a possibility that you lose and your patent becomes invalid.
Oof.
That means your patent doesn't exist. It goes away.
Oh.
There's a chance that you win and you continue to enforce your patent,
Mm-hmm.
and Mattel Toys takes it in the chin and they can't do anything about it, and they walk away. It is an awful process. It is a terrible process. And I can't believe they do it.
So is this part of it sounds like it's not necessarily part of the standard process, but it is something that can happen to an inventor.
Yes.
And it can happen
It's
after
one
the
of the-
patent is granted.
Yes, it's one of the pitfalls, right?
Okay. So what can you do anything to protect yourself leading up to that? It sounds like, being extra
Nope.
sure about your patent search, maybe, but sounds like
No, in our case, what happened with us is I didn't even know such a thing as an IPR existed. I thought once I get my patent, I'm golden, right? I'm
Mhm.
protected. And so that one competitor that I told you about earlier, when we went to them and said, hey, our patent has now issued, you guys owe us money. They said, well, we're going to file this thing called an IPR, Ed. And I was like, go file whatever the hell you want. We're going to sue you.
Mm-hmm.
Until I found out what it was. And it was like, you got to be kidding me.
Yeah. So, I mean, it sounds like the point of, having this is to make people aware of that, like you said, this is a pitfall, but this is a real thing that can happen. And, do your due diligence ahead of time, but just know that this is out there. It's one of those risks
Right.
that you take on as an inventor.
And I guarantee you, Annie, if you were inventing something that is novel and new, you would never hear about an IPR from anybody.
Thank you for tuning in to this episode. We hope you walked away with new knowledge and feel more confident in your patent journey. If you are interested in learning more about the invention process, follow us on Instagram at entrepreneurproject_ to be the first to know when our information-packed knowledge center will launch. Thank you.